Okay. Hi, everyone. Thanks for joining me. I am going to go over the recent rule the FTC made related to non-competes. And actually, I'm going to hold off just a second because some people are joining and I have to actually click to add them in. My name's Jessica Brown. I'm an employment lawyer here in Dallas, and one of my specialties over the last 20 years has been related to non-competes and trade secrets. So this is a pretty interesting topic for somebody who likes to nerd out on these things like me. Okay, I'm going to get started. So I labeled it, making sense of the FTC rule banning non-competes, because obviously the headlines are just kind of giving you the clickbait of, non-competes are invalid. But there's a lot of backstory to this. And, the short answer is don't panic and let's just hold off for a minute because nothing is going to happen right now. So on April 23rd, the FTC issued what it calls a final rule. And there's 570 pages of this rule, just FYI. And essentially, they have proclaimed that non-competes are an unfair competitive tactic and they should be prohibited. Since then, within 24 hours of that rule being issued, two lawsuits were filed, both here in Texas in federal court. One is in the Eastern District of Texas in Tyler, the other in the Northern District of Texas here in Dallas. And so that's kind of the second part of what I want to go into and explain why it's important that these lawsuits are filed and a little bit of background on the FTC. And I'll try to keep it like Cliff Notes because I know not everyone is actually interested in legal history. So the lawsuits are alleging that the FTC essentially is outside its scope of authority. So the Federal Trade Commission is an agency that was created by the Federal Trade Commission Act in 1914. And the purpose of the commission is to enforce the Clayton Act and the Sherman Act. And so those two bodies of law that were created by Congress sought to address monopolistic behavior. Particularly, this was around the time in 1914, this was around the time of Standard Oil, right? So all of this law was enacted by Congress to try to put a stop to that anti-competitive behavior and quote unquote, like break up the trust is what they said. So that's the origin of the Federal Trade Commission. Their authority is limited to enforcing those two acts. And those two acts deal only with monopolies, and essentially they're aimed at protecting consumers, right? You want to protect consumers that we're not being gouged by prices because one, monopoly owns all of the oil industry or owns all of the pharmaceutical industry or whatever industry it may be. So that's kind of the background on the Federal Trade Commission. The problem and what the lawsuits are seeking to address is that this commission, it's made of 5 commissioners. They're not elected, and they're not our legislature, right? We vote to elect our U.S. Senate members and the House of Representatives, and they are the only ones by the Constitution that have the ability to create our laws, right? And essentially what this rule is, they're calling it a rule, but they're trying to create new law. So the two lawsuits are challenging this rule as it's, way outside the scope, and it's effectively attempting to create new law where normally, we see these issues are managed state by state, right? California, in its own laws prohibits non-competes almost completely for employees, and it varies state to state. And that's why it's been for the last, 100 years. So the legal challenges that are being made are that, the FTC can't make this rule, they can't enforce it, and they should be stopped. And they're seeking immediate, like, injunctive relief, which means that the courts are being asked to tell the FTC, the agency, that they can't do this and they have to stop it. And so as of right now, there's been no ruling or anything, but I would expect you know, to keep your kind of eyes open, and I'll do updates, you know, as there are developments with this. I would expect that this rule is not going to stand. Certainly it's not going to stand as it is currently written, but I think it's probably going to go away completely. So that's a little bit about the background of the FTC and the legal challenges. And I thought now I would go into actually what these 570 pages of the rule actually say. A lot of them are the history, and the agency is actually going through, like, you know, trying to go through 100 years of law and justify why it thinks it can do this. To be honest, when you actually read all of that background, it's very clear that they know it's going to be challenged. They know that this is going to be a political fight in the courts. Okay, so I'm going to go through the actual terms of what the rule says as written. Like I said, I would say, you know, rule of thumb, like, let's not freak out, you know, just take a beat, take a minute. And as of now, nothing goes into effect. And the rule, although it was like pushed out on April 23rd, it's not been officially published. So they have to publish it in what's called the Federal Register, which is basically the way we archive agency rules. And it has not been officially published in the Federal Register as of today. And so on the date that it's published in the Federal Register, it doesn't go into effect until 120 days from there. So even notwithstanding the court, you know, the lawsuits and all of the challenges that are going on, nothing is changing, nothing is in effect right now. If there weren't legal challenges and it was going to, you know, move forward, we're looking at roughly September. Today is the 26th, so 120 days is, you know, end of August as of for right now, but I think we're probably looking at September if this were to go into effect. Okay, so the rule defines a non-compete clause, and I'm just going to read it here, as a term or condition of employment that prohibits a worker from, penalizes a worker for, or functions to prevent a worker from seeking or accepting work in the United States with a different person where such work would begin after the conclusion of the employment that includes the term or condition, or operating a business in the United States after the conclusion of the employment that includes the term or condition. I know that is not very clear. Essentially, what they're saying is, as of the date that the rule is effective, no non-compete can be enforced. So, you know, if you work, I'm going to say, in a pharmaceutical company and you're a sales rep, and you want to go work for a competing company and do exactly what you were doing for company A, you want to do it for company B, according to this rule, you're free to do that. You're also free to start a new business and compete against company A on your own as a new business. The rule does spell out some exceptions. The biggest one is if you're, like, they call it executive or highly compensated, and they define that as someone who has made $151,164 in the preceding year. So if in 2003 you're somebody that made over 151 and change, or if you made $152,000 and change, and you had a non-compete, then that existing non-compete could stand. However, going forward, there's an absolute ban. So that carve out is only for existing non-competes, for people that are highly compensated. Going forward, it doesn't permit any non-competes for anyone, no matter how much they make. And that's why businesses are going crazy, and the Chamber of Commerce has filed a lawsuit. The only other exception is related to the sale of a business. So if I own a business that, you know, makes pink widgets, and I'm selling that, you know, to person C who's going to take over my business, and we have a contract that, you know, for X amount of years, 3 years, 5 years, I won't make the same pink widgets, though that under this rule is still enforceable, and it's not any, it doesn't apply. The rule doesn't apply. What else? So garden leave, that's a term sometimes companies use where if they terminate someone, but they keep them on the payroll. Basically they keep them on the payroll, but they're not required to work. And it's called garden leave. In that situation, if there's a non-compete, the FTC says that the rule doesn't apply because technically the person is employed, and saying that they can't work for a competing business while they're employed is not prohibited under the rule. But it affects anything that once somebody is terminated, then they can work wherever without any limitation based on the rule. So, the way that the rule is written, it also suggests that any type of non-solicitation agreement or even non-disclosure agreements could be considered invalid. I think this is like a really far stretch. But basically they're trying to get to the position. It's similar as the position that the state of California takes, but obviously that was law created by their legislature, where any agreement that seeks to limit the ability of an employee to move and work wherever they want is held to be invalid. So that's the general kind of philosophy under this rule that they're hoping to promulgate. So, and I know I'm going like super quick. If anybody has a question, if you want to like speak up, chime in, I'm always happy to do interactive. I think that that's better because I can't, I'd like to know what you're thinking and the questions you have. To the extent I can answer them, I'm happy to. So kind of, I'm going to just kind of like circle back around because I went pretty quickly, and I know a few people joined after we started. First thing is, don't panic because this isn't in effect yet, right? So we're still waiting on this rule to be published in the Federal Register. Once that happens, which I don't know, I don't know if that's actually going to happen because there have been lawsuits filed and they're seeking to stop this from being filed in the public in the Federal Register. Once it's filed in the public register or published in the public register, then it's 120 days until it takes effect. So we're looking at the earliest that this could happen would be around September. Also, for those of you that joined a little bit late, so there are at least 2 federal lawsuits that are pending. They're challenging the authority of the Federal Trade Commission to make this kind of rule, because essentially they're trying to make law and they're not elected legislators. They're not, it's not our Congress, it's not our House of Representatives, it's 5 people who are unelected. And I have to say, of the 5 people on the Federal Trade Commission, this rule came out and it wasn't unanimous. So it was a 3-2 rule. So there's a split even within the Federal Trade Commission. They're not, there's not a clear consensus on them that, this is a rule that would be appropriate. So I would expect that these legal cases that are pending in Tyler and in Dallas in federal court, I would expect in the next week or so us to see some kind of action. I would expect one of those courts to issue what we call an injunction, telling the Federal Trade Commission that they don't have the authority to issue this rule. And if and when that happens, it will likely be appealed to the 5th Circuit. We have 11 federal circuit courts of appeals in the US. And so the 5th Circuit is the one that oversees Texas, Louisiana, and parts of Alabama. The 5th Circuit's one of the most conservative circuits in the country. It's widely known to be, corporate or company friendly, employer friendly. So I would expect if I had a crystal ball, I would expect that through the Fifth Circuit, the FTC rule is not going to be enforced or upheld. And from there, I would also expect that this will go all the way up to the US Supreme Court. And I do not anticipate the Supreme Court permitting this rule as written to go forward. So I don't know if anybody has any questions, as of right now, I would just say whether you're, on the side of the employer and concerned about your employees and your contracts and what do I do, just sit tight. You don't need to do anything or make any changes right now. Kind of status quo is fine. And, if you're an employee or you're an executive and you have a non-compete, I would have, the same advice. Let's just sit tight and kind of see how this plays out. I plan to do more of these and just kind of update people because it's faster and easier for me to just speak to a lot of people at once. When this rule first came out, I was getting texts and calls and emails like, oh my goodness, what's happening? Especially, CEOs and business owners and HR directors are like, companies that have large amounts of, high-level salespeople. Non-competes are an important aspect of their business and how they manage their salespeople. So, I think we'll just keep an eye out on this, and I will keep you all posted of any new developments. If anybody has a question, feel free to unmute or speak up, or you can. I'm not great at this technology, but if you want to type it in the chat, I'll also pull that up. Going once, going twice. Okay, well, if nobody has any questions, I really appreciate you guys joining me today. Like I said, if you have any specific questions, I'm more than happy. If you want to call, text, email me, I'll answer them privately. And just, stay posted. I'll try to update you guys as new developments take place. Happy Friday. All right, bye-bye, everybody.